right, good morning. We're on the record in the 89th District Court for the County of Sheboygan. We're here in the matter of contempt of Beth Bridgman. It was committed and filed under the case of People v. Seth Flores, filed 23-0868SD. Counsel, you want to state your appearance for the record, please?
Melissa Goodrich, White County Prosecutor.
All right, Ms. Bridgman is not present in the courtroom. Have we confirmed she's not out in the hallway? Okay, she's not out in the hallway. Ms. Bridgman was, the court issued a order to show cause why she should not be held in contempt for the unauthorized practice of law and also preventing defendant Flores from meeting with his attorney before his arraignment. I do see in the file a proof of service that she has been served with that, and in fact also in the file where Ms. Bridgman has returned the show cause cut.
From the very start, Thomas Styron walks into the courtroom like he's there to provoke, not participate. He insists on representing himself, but when the judge starts asking basic questions, he responds with smirks and laughter. That grin nearly cost him 30 days in jail. The judge doesn't hesitate, one more laugh and it's lockup. This isn't a stage for personal philosophy, it's a courtroom and the judge isn't in the mood for games. This moment sets the tone. Firm authority meets chaotic defiance. In less than 2 minutes, the courtroom shifts from orderly to volatile. It's clear, this man didn't come to face justice. He came to challenge it.
16, Ms. Bridgman is still not present in the courtroom. Is she present in the hallway?
Not present.
Okay, she's not present. This appears to be a willful non-appearance due to the fact that she's returned the show cause affidavit and the order with it cut into pieces with the red lettering. Your offer to contract is not accepted. Of course, it's not an offer, it's an order of the court to show cause. She has now willfully not appeared. Ms. Goodrich, do the people have a request?
Your Honor, at this time, since we're here on a show cause, she's been properly served and also given an additional 15 minutes to appear. We would ask for a bench warrant to be issued. No bond.
I think given the willfulness of the behavior, we'll set bond at arraignment. So I'll issue a warrant for Ms. Bridgman's arrest for her contempt for non-appearance today.
Right on cue, Styron launches into the sovereign citizen routine. I'm not Thomas Styron, I'm the living man. It's a confusing tangle of pseudo-legal language meant to derail the court's authority. The judge, however, stays laser-focused. Do you understand the charges? Styron responds with riddles instead of answers. It's courtroom theater, but it's not clever, it's self-destructive. The judge asks again clearly and firmly. No clarity. No cooperation. So, the judge dismisses him from the room again. This isn't legal insight, it's a refusal to engage with reality. The court can't function on ideology alone, and Styron is rapidly running out of patience from the bench.
Although I will represent myself.
Yes,
okay.
we'll get to that.
I would like to say I'm here on special appearance. No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
And you'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back around. Thank you. Okay.
We'll get to that in a moment.
So
but
I am
now's
waiving
not the time.
I am not waiving any of my rights.
Ma'am. Okay. Thank you.
Ms. Bridgman, you're free to stand or sit, whichever you're more comfortable with.
I don't know how I'd pull the chair up, so thank you.
Well, if you want to sit that, I have no problem. All right.
Thank you.
All right, well, Miss.
Here comes the truth bomb. 3 serious charges: fleeing and eluding, assaulting an officer, and driving on a suspended license. That's years behind bars if convicted. But since Styron refuses legal counsel, the judge reminds him, you'll be held to the same legal standards as any trained attorney. That means no shortcuts, no guidance, and no mercy for ignorance of procedure. It's a brutal warning for someone who treats court like a lecture hall. The message is clear. This is a legal arena, not a debate over personal beliefs. And without a legal strategy, Styron is heading into battle completely unarmed.
So therefore, I signed a warrant for your arrest for that non-appearance. So that warrant alleges that you are in criminal contempt for failing to appear at that show cause.
So
Failing to appear for order to show cause on Wednesday, December 20th, 2023 at 11 a.m. for preventing defendant Seth Miguel Thomas Flores from meeting with MIDC attorney prior to his arraignment. So those are the 2 contempt citations pending against you. You have the right to have a hearing on both of those allegations. your contempt would need to be proven beyond a reasonable doubt. You have the right to present evidence in your own defense and cross-examine and challenge any of the evidence presented against you. If you qualified and requested, you have the right to an attorney appointed at public expense. The MIDC provides an attorney for your arraignment today, just as a courtesy and as required by a
What is
statute.
MIDC?
Michigan Indigent Defense Commission.
You also, of course, have the right to represent yourself. Do you know, well, first, do you comprehend the penalties? Oh, I'm sorry, I didn't tell you. So both those contempt citations, if you are found to be in contempt or you admit to being in contempt, you could be punished by up to 93 days in the county jail and or a fine of $7,500 or both.
Turns out Styron had a public defender all along, but never reviewed the discovery materials. Now, the court is scrambling to get him the evidence, like cleaning up after someone who refused to prepare for their own trial. The judge tries to be fair, ensuring he gets the discovery before the next hearing, but Styron's attitude remains combative. He still throws around beneficiary and trustee, as if it changes the felony charges hanging over his head. This moment shows how the system bends to protect due process, even for those actively fighting it. The court's patience is wearing thin, and the countdown to the preliminary exam is officially on. Part 5. Now the wheels completely fall off. The judge confirms Styron is serving 30 days for prior contempt, and that's just the start. Styron begins ranting about Social Security, trusts, and legal identities as if he's explaining a conspiracy instead of facing felony charges.
And she said, he can't serve a show cause. I shot over a copy of it. He can't serve a show cause because you're not under bond. This is from the state attorney general's office. I was still on the phone with her. I had filed the paperwork at 9 o'clock. She called me at approximately 10 o'clock. I was still on the phone with her till after 11 o'clock. And she told me that you could not issue a show cause because I was not under bond. Now I understand you have just precluded all of my common law rights by forcing me in the back door into your jurisdiction on this side of the court. And I know that this is not what was on the original document in its entirety. So you have amped up the charges based on the fact that I failed to appear, but I believed she was going to let you know. She was collecting information from me for you.
Ma'am,
Okay, now,
just understand what the judge asked you regarding those two charges.
Did you just understand that I think there's a bigger overriding issue? Thank you.
Hang on.
Thank
I'm
you.
not going to have this.
I'm going.
Done playing referee. The warning is blunt. Keep talking like this and you'll rack up more time. It's no longer just about legal missteps, it's about basic courtroom behavior. The judge asserts control, shuts down the sovereign theories, and reestablishes who's in charge. The courtroom isn't a place for wild theories, it's a place where facts and accountability rule.
For you and the penalties.
Why have they changed,
I'm
Judge
not
Becky?
answering that question.
Can the prosecutor?
No,
Why?
I need an answer to my question. Do you understand that? So you said you want to represent yourself, right? You wish to represent yourself and not have an attorney represent you?
Yes, I
Okay.
do.
If you want to do that, I must establish that you know what the penalties are and what your rights are. And I have to establish that you're not going to be disruptive to the court. If you refuse,
So are those,
then I'm going to appoint
I'm not
an attorney for you.
refusing.
Okay, then I would appoint an attorney for you and you'd not be able to represent yourself.
I know, I listened to that with Trevor's case.
All right, so I'm asking you, and you saw what.
How
happened,
can I
Ms. Bridgman? So I first have to make sure you know what the maximum penalties are and what your rights are. Do you not?
Those maximal penalties are based on the charges, and I'm wondering how you arrived at a change in the charges.
You know that you could face up to 93 days in jail and over $7,500 fine. You understand that?
Up to that. Okay, but I don't even understand what the charges are.
Okay. And do you have any questions for me about any of the rights that I listed, that you have to have an attorney and have a hearing and present evidence? Do you have any question about any of those rights?
I have a whole question about the whole context of everything today, Judge Gothier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you?
No, it did not offend me. It was a contempt of court.
As the hearing ends, Styron's fantasy meets the crushing weight of legal reality. His sovereign arguments have no power here. The court functions on law, precedent, and order, not on trust declarations and semantic games. The judge issues a final warning. This path only leads to more jail time. Styron's belief system isn't protecting him, it's isolating him. His refusal to engage with basic legal procedures shows the danger of misinformation, especially when liberty is at stake. This isn't an internet comment section. It's a courtroom. And it just handed Thomas Styron a harsh lesson in real-world consequences. Do you think he finally gets it?
Or everything, I see. Okay,
So I can schedule this for a contempt hearing on Thursday, January 11th at 2 p.m.
I think that would be way too soon for me, thank you.
Why is that?
I need to get to some of the documentation and follow up with that state trooper, as well as perhaps a few other people, because I'm guessing, am I supposed to just talk to the prosecutor without the other witnesses that I had in my presence at the same time?
I could schedule this for the afternoon of Thursday, January 25th. Then that gives you 3 weeks.
Thank you.
So we'll schedule this for a contempt hearing on both allegations of contempt on Thursday, January 25th at 2 p.m.
Applies to the Michigan code and statutes.
You have all the rights in the Bill of Rights. I recognize all those constitutional rights.
And most of what I talked about actually falls under common law because it's common that anyone could understand it.
All right.
That's
so
why it's called common.
We'll set the hearing date.
Okay.
We'll arraign you on the charges. I'm going to recognize that you are exercising your right to represent yourself and discharge Mr. Villanueva from any further responsibility in the matter. The only other question I have to decide is whether you should be released on your own recognizance, or whether you should be required to post a bond. But I'm going to hear first from the prosecutor and then from you on that question. Ms. Miller?
Your Honor, I would object to a PR bond in this case first because of the her failure to appear on December 20th. She had notice of that hearing date as she dropped off the show cause